Good afternoon. Welcome to the final session of Must Know March. Today we'll do things a little differently. Over the last couple of Fridays, you may have seen Diana and Agenta deliver these sessions, but we've booted them and have replaced them with me. Hi, I'm AID, the Senior Legal Counsel and Privacy Officer at Transdev. We did warn you that robots were taking over, LOL. So sit around for the ride because we are talking about privacy today. Privacy is relevant to all of us in one way or another. That's why in today's session we will cover the following topics. Why we care about privacy. What is personal and sensitive information? The legislative framework that impacts Transdev. Privacy and artificial intelligence. The Optus data breach as a case study. And finally, Transdev's privacy policy, the data breach response plan and our collective obligations as Transdev employees. So to start off, privacy is valued for a number of reasons, both at individual and societal levels. I mean, would you feel comfortable if your neighbor was peeking through your window without your consent, watching you eat dinner with your family? No. That is why we value the fundamental right to privacy. A few other reasons we value privacy include autonomy and control. We want to ensure that we're in control over our personal information and to whom we reveal our information to. Safety and security. Protecting personal information helps safeguard individuals against various forms of harm, including identity theft, stalking, and other types of cybercrime that can have devastating financial and emotional impacts. Freedom of expression. Privacy fosters a sense of security that encourages freedom of expression. When people feel like they're being watched or monitored, they are more likely to self-censor, which can prevent freedom or thought of expression. Social boundaries. Privacy helps maintain social boundaries as it allows people to manage different societal roles and relationships, effectively deciding what parts of their lives they choose to share in various contexts. So to summarize the items mentioned, privacy is fundamental to the functioning of a free society, allowing freedom of expression, autonomy and the maintenance of safety and dignity. Privacy is a fundamental human right that underpins freedom of association, expression as well as freedom from discrimination. The term privacy is difficult to define as one's privacy is not absolute. In the Cambridge Dictionary, privacy is defined as the right of someone to keep their personal life or personal information secret or known only to a small group of people. The second part of this definition demonstrates that complete privacy does not exist. Therefore, the legislation with respect to privacy does not revolve so much around maintaining and keeping personal information private. In this day and age, that has been proven to be difficult. Instead, privacy legislation focuses on how to appropriately handle personal and sensitive information. Therefore, just like sharing a secret with only a group of people you trust, you want to believe on a larger scale that your personal information is handled in a manner you can also trust. Let's consider the two types of information privacy legislation aims to protect, starting with personal information. Personal information is information or an opinion and about an identified individual or an individual who is reasonably identifiable. Regardless of whether the information is true or not and whether the information or opinion is recorded in a material form or not. There is no requirement that the information to be deemed personal needs to be private or confidential in nature. For example, if I gave you Diana or Agenta's full name, residential address, email address and their phone number, you would be able to use that information to look them up and identify them on LinkedIn. And no, this is not a sad attempt from them to make new friends and connections, because that would be #desperate. We care about personal information and the privacy obligations attached to it because as an organization we collect personal information throughout our duties, whether it be information of customers, clients, suppliers or other contractors. In the course of our operations as public transport operators we collect personal information, for instance CCTV footage of passengers on one of our buses or light rail vehicles. We should also care about how information is collected and handled because Transdev is subject to legislative and contractual obligations to protect privacy. Sensitive information refers to information that has the potential to trigger prejudice or bias. It can include one or all of the items shown on this slide. The reason we care about sensitive information is because Transdev as an employer has access to certain information about employees. For instance, health records or criminal records for the purposes of conducting background checks during a recruitment process. There is a general expectation that due to the nature of sensitive information that it will be given a higher level of protection than non-sensitive information.
Hi, I'm Nathan, the Chief Legal and Commercial Officer. AI style, and just like the real-life Nathan, I know a lot about legislation. I'm here to speak about the Australian Privacy Act. Transdev is influenced by various pieces of privacy legislation, both on an international, national and state scale. As the legislation in each state mimics the national privacy laws, we will focus specifically on the Australian and New Zealand's Privacy Acts. However, it's important to keep in mind that Transdev also has contractual privacy obligations to our public transport clients to keep information confidential unless the law authorises otherwise. For instance, in New South Wales, government agencies have an obligation to comply with the Government Information Public Access Act, also known in its abbreviated form as the GIPA Act. GIPA allows members of the public to make a request for information to government agencies, such as Transport for New South Wales, who is a government agency and one of our PDA clients that we contract with to operate public transport. As part of our contractual obligations, we are required to comply with the GIPA legislation, which allows Transport to consult us in relation to any personal information that we may hold about the relevant GIPA request. If you receive a similar request from one of our PDA clients, it's best to touch base with the legal team who will advise the necessary steps forward. Although, for the sake of this session, we will look at the national privacy legislation. Privacy in Australia is primarily governed by the Privacy Act. The Act regulates the handling of personal information by government agencies and certain private sector organisations. Some key areas the Act addresses includes the 12 privacy principles covering the collection, use, disclosure and storage of personal information. Organisations must manage the collection of personal information in an open and transparent way and allow for individuals to access and correct the information held about them. The Notifiable Data Breach Scheme. Over the last few years we have seen an increase in the number of national data breaches. Some you may have heard of include the Optus and Medibank data breaches. The Privacy Act anticipates these events happening and sets out the process as to the steps to take if a data breach were to occur within an organisation. It requires organisations to have a data breach response plan in place, setting out the process and procedure that staff must follow in case there is a data breach. It also requires organisations to notify the Office of the Australian Information Commissioner if there is a data breach likely to result in serious harm to an individual. In line with the legislative requirements, Transdev does have a data breach response plan in place which will be covered later in this session. Organisations must obtain consent to collect, use and disclose personal information, with a focus on informed and voluntary consent. This is where the privacy policy comes into play. Have you ever filled out a form whereby you acknowledge that you agree to the organization's privacy policy? Well, that sets out the terms of collection and handling of your information, and you provide your tick of approval by clicking the particular tick box before pressing submit. Otherwise, organizations such as Transdev have their privacy policy publicly available on our website that informs individuals that their personal information is collected, the purpose behind the collection and steps to access and, if required, correct the information. The Act also regulates the disclosure of personal information to overseas recipients. The Privacy Act does not entirely restrict disclosure of personal information to overseas recipients, as this would be too difficult, given that we live in a globalized era whereby the data flow of information online is significant. However, the Privacy Act requires that the overseas recipients must be able to show compliance with the Australian Privacy Act and the privacy principles. If you intend on using a supplier or contractor from overseas, you best bet that the legal team will be asking questions such as, where in the world is the data collected stored? Does the entity have a data center in Australia? Where in the world is the supplier or contractor located? Not only do we as an organization have a duty to comply with the set legislative requirements, but some of our operating contracts go a step further and do not allow for data including personal information to go outside of Australia or even the particular state. That is why we have to be cautious in our dealings with overseas suppliers. And finally, individuals are able to lodge complaints about privacy breaches with the OAIC, which has powers to enforce privacy laws and impose penalties for non-compliance on organizations. The fines for non-compliance and contravening the Privacy Act can be up to $50 million, 3 times the value of benefits obtained by an organization, or if the court cannot determine the amount of benefit obtained by an organization, then 30% of its adjusted turnover during the breach period. The Australian Privacy Act underwent a massive review by the Attorney-General's Department, as it was widely believed that the Australian Privacy Act does not adequately reflect the current digital era we are living in, which is the era of AI bots like me. The result of the review was a report where a total of 116 recommendations were made to align the Act with today's digital era. The government has agreed to 38 of the 116 recommendations and has agreed in principle to another 68 which are subject to further engagement with businesses and a comprehensive impact analysis before the government makes a final call. Of all proposed recommendations, some include strengthening the notifiable data breach scheme by proposing tighter timeframes for reporting breaches to the OAIC and the impacted individual. Changes to the enforcement regime by giving a court the power to make any order it sees fit once a privacy interference has been established, as well as increasing powers and obligations of the OAIC. Another recommendation is the requirement to act fairly and reasonably when collecting, using, or disclosing personal information, whereby organizations will have to think about the reasonable expectations of the individual whose personal information is being collected, including the type of information collected, its use and sensitivity, as well as whether the impact on privacy is proportionate to the benefit. The report also proposes mandatory privacy impact assessments, PIA, for any activity deemed a high privacy risk, which would encompass undertaking a risk analysis of activities that are likely to have a significant impact on the privacy of individuals. Further to this, another one of the recommendations proposes introducing the right of erasure, which would provide individuals with the ability to request that an organization deletes personal information that it holds about the individual. This right of erasure is essentially an extension of the obligation to delete personal information once it is no longer required. None of these changes have yet been formally reflected in the Australian Privacy Act, but definitely watch this space as changes are coming which will further align the Australian Privacy Act to the European GDPR, which we look at later in this session. I know that I'm an AI bot, and it is a little ironic that I'm covering this very topic, but I just wanted to raise that there is a significant increase in the use of artificial intelligence technology such as ChatGPT, Microsoft Azure, and more in today's day and age. These platforms certainly improve efficiency in many different aspects. However, it is important to be aware of the risks associated with the use of AI and the do's and don'ts. It should be noted that AI-generated responses are not always 100% accurate, and to fact-check your AI-generated responses. Also, it is vital to ensure that no personal, sensitive, or confidential company information is fed to AI platforms, as this may result in a breach of Transdev's contractual obligations to our PDA clients, the applicable privacy legislation, and the newly developed Transdev Code of Conduct about generative artificial intelligence. The Transdev Code of Conduct on AI does not prohibit the use of AI technology but asks of caution to be taken to prevent any confidential company data, personal or sensitive information, from being communicated to the AI platform. Therefore, if we cannot beat the AI bots, our only option is to expand our knowledge on AI technology and platforms, such as the one used to create this must-know March session, otherwise businesses and organizations risk getting left behind with outdated technology. Given my lack of accuracy, I'll throw this session back to Diana and Agenta. At least I've given their voices a break after 4 weeks of presenting. It was great to meet you all, but I think I'll let Agenta and Diana keep their day jobs. But first, a short video addressing the Privacy Act review and AI.